And it comes before the court today on defendant Ms. McClinton's motion to consolidate this case with another case, which is McClinton versus Varney and all 26-20661. The Varney action, which to my understanding is pending currently, at least in front of Judge Quist. As an initial matter, counsel, will you place your appearance on the record?
Yes, good morning, Your Honor. Evan Kuiper on behalf of Roxana Barnaby and Stephanie Lester.
Very good. And Ms. McClinton, you are appearing on your own behalf in this matter.
Yes, Your Honor.
All right. Well, Ms. McClinton, this is your motion, and you've correctly identified the court's discretion to consolidate cases when there is a significant overlap regarding the issues. The primary objection that the plaintiffs in this case have raised is, well, the other case is complicated by the fact that Mr. Varney is, a prolific writer, filer, and litigator, and complicates and drags out that case. Why would we want to bring that mess into this case? So, what's your response?
Yeah, certainly, Your Honor. And I would like the court to know as well that originally this all started off with a district court case 25-10927 GC, where I was actually pursuing a global settlement with all parties. So with this scenario, Your Honor, I would like to pursue the same. I would like to add to the court to consider as well that there is regular communication going on between Roxana Barnaby and Chad Varney. I would like the court to know that I actually received correspondence on June 11th at 3:28 a.m. as well as this morning at 12:20 a.m. Those emails were sent to myself, Mr. Kuiper, as well as Roxana Barnaby about just some filings and things. From my standpoint, all of the parties are the same, Your Honor. We're dealing with the same property boundaries. All of the evidence is being exchanged amongst Roxana Barnaby as well as Chad Varney. From an efficiency standpoint, this has been going on for over the last year. We need to have everything on the same scheduling order, and in my opinion, everything should be aligned.
Okay, all right, and I'll give Mr. Kuiper an opportunity.
Thank you, Your Honor. Just real quickly to address what was just said, I'm not sure why I've been copied on these emails from Mr. Varney. I don't represent him. I represent his mother. The mere fact that he is sending me and copying me on these emails does not make him a party to this action. And again, he's filing tons and tons of motions. If you look at the circuit court docket between May 4 and June 11, he has filed roughly 32 different motions. And these motions include emergency notice of criminal forgery, material alteration of signed judicial order, emergency motions to disqualify judges. These are not the same legal issues that are being litigated. Sure, the initial underlying factual cause of the dispute is the same, but all of the legal issues that are being raised by Mr. Varney are inherently different than the claims in this action, and forcing my clients to deal with Mr. Varney in litigation with his serial motion practice would incur significant undue burden prejudice through extra costs, time delays, and to address the risk of inconsistent rulings argument that Ms. McClinton raised in her motion. A final judgment on the property issue here will almost certainly have a preclusive effect on the issue in the Varney case. The trespass claim against Mr. Varney, it would essentially be res judicata or collateral estoppel. And if the court or Ms. McClinton is further concerned about the risk of inconsistent rulings, the proper course would be to stay the Varney action pending the resolution of this case. And based on the substantial prejudice that would accompany the consolidation of these matters, we would request that the court respectfully deny the motion.
Which of your clients is did you say the mom to Mr. Varney?
Yep, Roxana Barnaby is his mother.
Okay. And now, Ms. McClinton, and it's certainly understandable if they are mother and son, that these two would be communicating, and she's essentially saying, "Hey, if that's happening, let's just call this what it is and bring these two cases together." And all the, why wouldn't I do that if there's already quite a bit of coordination going on between mom and son?
Certainly, Your Honor, and if you don't mind that I add, Mr. Varney is also claiming adverse possession to the property. And in addition, I've been sent correspondence via email and, to my home of photographs from Roxana to Varney. And those are actually depicted, and I went ahead and uploaded those to the docket as well.
All right. Well, I directed that question actually to Mr. Kuiper. Let me hear Mr. Kuiper's response.
I'm sorry, Your Honor. I was under the impression you were directing it to Mrs. McClinton. Why
That's
should they
okay.
not
I
be?
confuse people all the time.
The question was, why should they not be consolidated if there is
Yeah, if there's
communication?
already this open communication between Miss Barnaby and Mr. Varney, they're acting in effect as a, single party in the matter. Why shouldn't I consolidate?
Because they're a mother and a son, and they communicate about their distinct and yet unrelated legal actions. And the significant number of issues being raised by Mr. Varney is inherently different than the actions in this case. Mr. Varney may claim adverse possession, but he doesn't own the property. He can't claim adverse possession. Just the legal issues that are being raised by Mr. Varney are completely different than the rather straightforward quiet title and trespass claims before this court.
Okay. And I do have a second question
Yep.
for you, Mr. Kuiper, that occurred to me as I was reviewing the briefing yesterday, and that, there are two things that Miss McClinton mentions. The first is a consolidation of the legal cases, which, can be done under the court rules, and I have a huge amount of discretion as to whether or not to do that. The second is, should I simply move the Varney case from Judge Quist's courtroom to me, not because I'm a glutton for punishment, but because we do have a policy that related cases should be heard by the same judge. And I think particularly Ms. McClinton said, well, in an ideal world, we'd get a global settlement here. It might make some sense to have me involved with both cases. What are your thoughts on, even if I don't consolidate, requesting that Judge Quist transfer that to me, which, knowing Judge Quist and a prolific litigant like Mr. Varney, I would do that in about a millisecond, and I'm confident Judge Quist will do the same and send it to me. What are your thoughts on that?
I think that would be a much better option. The purpose of consolidation is to avoid unnecessary costs or delay. And in this case, consolidation does not seem appropriate because it would increase costs and delay the adjudication of the case. But having one judge hearing both cases, I think, would be beneficial for all parties while still keeping them separate.
Well, from my understanding, Your Honor, there is a motion for summary of disposition later down in August. So, in the opinion that it would increase costs and time, we already have a motion that's scheduled here in the near future. So, really,
In this case, Miss McClinton?
yes, sir.
Yeah, okay. So I'm gonna potentially decide the case in August, although of course summary disposition sometimes does dispose of the entirety of the case. Sometimes, particularly, and I don't know any of the particulars of this case. I just looked at the legal issues in a property case. Sometimes some things get resolved and some don't. So
Mhm.
it could be a mixed bag after August. Well, yeah, no, I get that, and I totally get what you're saying, and also that I'd be concerned as well as is, who's calling the shots here? Is it Mr. Varney? Is it really his mom, Miss Barnaby? Are they working hand in hand? And
Mhm.
that's impossible really to see. I can't see the number of filings. I mean, I only have to
Yes, sir.
glance at the record of the court,
Mhm.
and I can see what Mr. Varney's been up to in his case, and so.
Certainly.
At this time, what I'm going to do is I'll deny the motion for consolidation without prejudice. I can do that anytime, and you can re-urge the motion at any time if we narrow the issues down or if it becomes more clear, for example, in August after summary disposition that that's appropriate, we can do that again.
Mhm.
And I'll also, as much as it pains me to do, um, request from Judge Quist that he transfer, because it looks like the older case is this one, and that then the case from Varney versus or McClinton v. Varney is newer. Is that right?
Correct, Your Honor.
That's correct.
Yeah, yeah, then that should, our other rule here in the court is, the first judge it gets in front of should be the judge to handle all the related claims. I'll suggest to Judge Quist, and like I say, if it were me in that same situation, I would be more than happy to be rid of all those filings from Mr. Varney. So I'm confident Judge Quist will do exactly the same thing, and that they'll
Judge,
both get in
excuse me,
front of me.
it's already been transferred to you.
Oh,
It's already been.
Judge Chris got ahead of even my request to transfer. Well, there we go then. All right, then it's going to wind up in the same place, and we can readdress if necessary that consolidation
Sure.
motion. But the one thing that gives me pause here is the volume of filings for Mr. Varney, and I certainly agree with Mr. Kuiper that and having experienced with litigants that file everything, including some stuff that probably shouldn't be filed, then that can really complicate and drive up the expense of a different case. So I don't want to, kind of get stuck in a quagmire here with those two things in the same case. It could overly complicate it. So let's keep the cases separate, but they'll both be in front of me.
Very well, Your Honor.
Understood. Thank you, Honor.
Thank you.
Have a good day.
You as well.
Have a good day, everyone. Bye-bye.